Good evening to those of you here in the room, and good evening to those of you listening to us via a computer screen. My name is Christopher Vajda, and I've been asked to chair this extremely interesting evening, and I congratulate Andrea, Biondi and Kings for putting on this evening event to discuss a judgment that was delivered just 1 month ago, because today is the 8th of December, and from memory, yeah, this was the 8th of November. I thought that I ought to at least read the judgment, but as I'm not a speaker, I haven't done more than read it. But I think it'll be an extremely interesting evening, because from my reading of it, I mean, this is not only a state aid case, this is also a case on competence of member states and the distribution of powers within the European Union. And of course, the importance of the case is highlighted by the fact that it was a Grand Chamber case. And during my time in Luxembourg as a judge, it was the exception rather than the rule that state aid cases go to the Grand Chamber. So that shows the importance of this case. Now, happily for me, and possibly also for you, I'm not going to do much speaking at all this evening, because we've got five excellent speakers who I'm now going to introduce to you. And starting on my left, your right, known to most of you here, if not all of you, Andrea Biondi, who's Professor of European Law and Director of the Centre of European Law at King's. And then on my far right, we have Sarah Blakelock, who is a partner in Deloitte's, I like this, Controversy Network. That's going to explain to us quite what that is. Then to my immediate right, we have Stephen Daly, who is Senior Lecturer at Law here at King's. And then to my immediate left, we have Paul Davison, who is a partner at Freshfields, Bruckhaus, Deringer, where he heads the finance tax team. And hopefully behind me, yes, I see her there, is Ruth Mason, who is the Edwin S. Cohen Distinguished Professor of Law and Taxation and Director of the Virginia Center for Tax Law at the University of Virginia School of Law. Now, our panelists have been hard at work in discussing how we are going to proceed this evening. And they provided a little crib sheet, or Stephen has actually provided a little crib sheet for me, so I can ask some questions which are not spontaneous, but have been drafted. And I also know to whom the questions should be directed. So, and I think what we want to do is to make this evening interactive. So we'll ask the question, we'll then have the response from the speakers, and then we can then other members of the panel can chip in. And if there's anybody from the audience who wants to chip in, please do so. So now the first topic that we're going to discuss is this, that the arguments advanced by the Commission, and this is in the Fiat case, and just to remind all of you who haven't perhaps read it up, of course, when you have a state aid decision, the Commission takes a decision on the basis of Article 107 of the treaty, and that decision was then appealed by Fiat, Luxembourg, and Ireland to the General Court. The General Court upheld the Commission's decision, and there was then another appeal to the Court of Justice, and that was the case that I mentioned a moment ago that went to the Grand Chamber, and the Court of Justice overturned the decision of the General Court. So the first topic then is the arguments advanced by the Commission appear to have shifted considerably over the course of the litigation in the Fiat case. Would the following characterization be correct? That the Commission's opening decision looks very different from its final decision, which looks very different from the General Court's decision. And I'm going to ask Paul whether he'd like to address that issue.
I'm going to let Andrea go first on that. If that's,
Okay.
Make sure you tip the mic over there so that that mic can hear.
I thought I had some time to copy it from what you were saying. All right, okay, no worries. Now, if you don't mind, perhaps just before talking special, I'd like to simply say that the whole credit goes to Stephen. That we only pay for the drink, but Stephen did all the job, all the work, organizing the thing, finding the speaker. So thank you very much, Stephen. Really appreciate it. Second preliminary remark is that obviously I am surrounded by tax experts, and but this is one of those cases which is quite intriguing because two different, slightly different communities, as EU law or state aid experts, they need to confront with a, well, I would say, a bit of a different topic. So hopefully, as I said, I will try to keep some remarks more on the EU law state aid side. Now, in terms of the Commission, I mean, obviously this is a long story. It's been going on for many years, and I'm not sure that I don't know whether we can speak about sort of that something has changed in comparison with the opening decision, because the opening decision is dated to 2015 one, so more or less all the arguments are there. I think that the point here, the intriguing point, is that the Commission took the decision to litigate on a very specific point, or you can put it on, they put all the eggs in one basket, and they came up with this idea that you can use a sort of European arm's length principle that the Commission used in order to measure whether the Luxembourg tax ruling conferred an advantage to integrated companies. Now, obviously, again, for state aid lawyers, we've been discussing for 50 years or more whether the advantage requirement is exactly the same as selectivity, whether they should be kept distinguished, what's the impact of one criteria on the other, and so on and so forth. Usually, how to determine an advantage is not such a big deal because although it's difficult in practice, usually you apply what we call in state aid law the market operator principle, you compare the behavior of the state with that a normal undertaking, and then you decide. It's complex in practice, but as a general principle, it's okay. It's a little bit more difficult in the area of tax because of what you compare with. So I think that intellectually, I think that the Commission came up with a rather intriguing idea that the arm's length principle was a sort of de facto market operator principle, because the Commission said, well, this is the way to show that basically the market rules had been followed.
That's not where we thought it was.
That's not where we start. Exactly.
We thought it was a challenge to lax tax ruling.
But
practice.
Exactly, and that's my point, because they clearly decide to litigate on this point. And you have to keep credit. They managed to persuade the General Court, because the General Court said, yes, that's a really great idea. You have now this general principle of arm's length principle that can be applied to Article 107, paragraph 1, go ahead. And actually, if you look at the judgment of the General Court, with all due respect, on that part is a bit strange. Because first, the General Court says, yes, the Commission can use the OECD principle as a tool. And everybody asks, okay, what does it mean? A tool could be a lot of things. Then that can be used as a benchmark, and then can also be used as a general principle. So we go a little bit lost. And obviously, the Court of Justice had none of it. So in that respect, the judgment of the Court of Justice is truly different. Because whatever, in terms of state aid law, the CJU judgment is very classic. It's all about selectivity. Selectivity is one of the other criteria to determine whether a certain measure is state aid or not. And the test of selectivity has three parts: identification of the general framework, comparability between undertakings, and possible justification. This arm's length principle, whatever, is not there. It's not there. Court doesn't even discuss it at length. They simply say, because the main point is that you have to identify the general framework. The Commission got it wrong because they came up with this abstract idea of Luxembourg corporate taxation. They should have simply stick to national law. They didn't do it, and then therefore not only the Commission decision, but also the General Court decision has to be annulled. So the first, shut up. The first point is that probably all this idea of a EU arm's length principle is dead. the court also treated like, the commission based all this reasoning on one single judgment of the court, the 187 forum, court says it doesn't matter. I think it's probably dead. And something that, if I may add the last point, commission must realize that probably something has to change. What the European Commission did quite cheekily was to insert this idea in the notice of the definition of state aid, which is now the sort of the instruments that everybody uses. It's a sort of a soft law instrument where the Commission explains this is what state aid is. It's not the role of the Commission to define what state aid is, it's the Court of Justice. So in this document, you have all these principles, state aid, with the footnote, as the court explained in blah, 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 with one exception, the arm's length principle, which the court said, the Commission said, this is now a general principle of state aid, blah, blah, blah. And in the footnotes, they put the Commission decision of 2015. And I'm afraid it looks like probably they might need to change that document. I think that's the first comment. That's probably gone.
Tilt the mic over to the phone.
Sorry.
I think that sounds quite promising from a practitioner's point of view. As I was saying before, I think that the perspective I would have on this as a tax lawyer is that the start of this journey seemed to be a perception, rightly or wrongly, that certain tax authorities in the EU were doing overly friendly deals with multinationals. And that could be Fiat, it could be Amazon, it could be Starbucks, it could be Apple, allegedly. And the notion in that context of state aid being conferred through the tax system was actually fairly easily understood, in the sense that you have some rules, you have the tax rules, and you can call it the system of normal taxation or the reference framework or whatever technical term you want to use, but you have some rules, and then the tax authority, on a basis that is plainly selective because it involves saying to a particular taxpayer, here, this is how the rules can be operated in your case, that tax authorities were agreeing to an application of their rules that was not actually in accordance with the local domestic legislation. And in those circumstances, you could quite readily, to my mind, as someone coming to state aid very late in the 50-year party, you could see how that would be state aid. It would involve conferring an advantage using state resources, doing it on a selective basis. And so it's been interesting then to see how over the course of the 7 years or so, actually this has developed into really quite a different argument over the interaction between state aid and tax rules, and in particular an argument over whether actually it's inherent in the way in which all member states seek to tax companies that they should do so on a basis that respects the arm's length principle where transactions are entered into between related parties. And that, I think, is quite a journey from beginning to end in terms of the litigation. And certainly from my perspective, it was refreshing to see the Court of Justice not entertaining the Commission's view of what was inherent in Luxembourg's tax system and what should have been found there regardless of the domestic rules as written in terms of the arm's length principle.
Now, Stephen, Sarah, do you want to? Ruth, do you want to chip in at this point?
Yeah.
Okay, right, then Sarah. Nothing to say about this. Okay, well that's. Well, let's just see whether there's anybody else who. I mean, Stephen, do you want to say any comment that you'd like to make?
Well, yeah, I will just mention about Luxembourg in particular, because this case is about Luxembourg, and the what started this all, it looks like it was a LuxLeaks back in 2013, 2014, bit of background. And in Luxembourg at the time, taxpayers went to this person, Marius Cole, who ran the tax authority, and they got tax rulings from this person. It was a single person in the tax authority that gave these rulings. Omri Marian in the States, he did a stellar job of looking through all of these LuxLeaks rulings and found various quite concerning things about the way in which tax administration was done in Luxembourg at the time. So in a single day, there were 11 applications for a complex tax ruling, 8 of them were granted. Just for a little bit of context, in the UK, it takes between 1.5 years and 2 years to get an advanced pricing arrangement. In cases like Amazon, a complex ruling was granted after 11 days. There was very little contemporaneous evidence to back up the ruling. And there was also a cosmetic presentation of the facts and the figures. Same thing with Fiat. So you look at the Fiat ruling that was granted, and it seems quite flimsy. Like the paper request itself just seems quite flimsy. And that's what started off these investigations. And then the cases just metamorphose into a discussion of the arm's length principle, what the arm's length principle means, whether that's to be found in domestic law, EU law, international law, whether it's part of customary international law, all this kind of nonsense. But it started off with, I think, a valid concern about the way in which tax practices were, the way in which tax administration worked in Luxembourg back in 2014.
I think that's extremely interesting because it reinforces the old adage, hard cases make bad law. You can see that effectively, both what Paul and Stephen were saying is that the Commission then thought, well, you know, this is something we've got to act on. And then when you start pulling the leaves off, you then say, well, what's the principle underlying this? Now, before we move on to the next topic, is anyone in the audience who wants to add, comment, disagree on what we've discussed in relation to the journey from the Commission to the court? No, well then I think in those circumstances, and this would be a good opportunity to bring Ruth in. Then the next topic, and I will read it out so that you, the audience, know what it is. Would it be fair to say that the ECJ's decision is an improvement on General Court's decision in terms of clarity? And I think to lead us on this will be Ruth.
Hi, everybody. Thanks for inviting me. I'm glad to be here. So for me, I think it's an improvement on clarity, but I think more importantly, it's an improvement on the theory of the case. So the General Court basically approved the Commission's theory of the case, kind of. The General Court had said that the Commission could use the OECD arm's length standard to check Luxembourg's ruling practice. The problem was it had done it wrong. But here, you know, in the General Court, in the Court of Justice, that they made clear that the Commission is bound to use the member states' actual law as the reference base, going back to an earlier standard. And, you know, this, as the court itself observed, is important for notice to taxpayers and to protect member states' reserve sovereignty. And I would also add that it's an important check on the discretion of the Commission. I mean, you know, Paul described himself as coming late to the state aid game. I mean, I'm American. We came really late. But the impression that we got, you know, as non-Europeans is, wow, the Commission has just run amok. I mean, it's just doing whatever it feels like doing, and there are no rules except those that it writes into the notice based on its own cases. So that was concerning from an outsider's perspective. Applying the law retroactively, right? Inventing the law, then applying it retroactively to the states. All of these things were very concerning to outside observers. And I think that to its great credit, the Court of Justice sort of put the kibosh on all of that.
I might chip in with something slightly controversial or deliberately provocative, which is to say that, again, somewhat as an outsider, and particularly nowadays as an outsider to European courts, I certainly found the General Court decision extremely hard going and very long and not very clear. So I certainly read the CJEU judgment and found it rather clearer, at least in the first part. I think it's still read as a judgment where the court had made up its mind on the main point and then decided it didn't really need to consider the other ones for reasons that were a bit less clear. But it was certainly welcome to me to read a shorter judgment and one where there are not endless paragraphs where they start saying, as can be told from the following cases, here are some principles, and then next paragraph, here are some other principles, without a great deal of insight or analysis. But that may be too provocative a view of European courts.
No, I think that is what some of us called the Lego style of judgment, which I personally hate enormously, because you read these immensely long judgments and then they recite all this stuff, these previous cases. And in fact, sometimes they don't recite it fully accurately because they say, well, en effet, and the moment you see en effet, in effect, your antennae should come up, because in fact, what they've done is they've very subtly changed that. And then you get to the actual meat of the judgment, the reasoning, which can be very short. And I think what Paul has described in what I might say measured tones that one would expect from a partner at Freshfields is entirely right. And I mean, the judgment of the court itself is itself quite long, but of course it is an appeal. You've got to go through all the arguments. But I think the points that Paul made in terms of judgment writing are points that are very well made. Now, let's have the view.
Let me just add one comment on the court itself before, because of course, you know, we're looking at these judgments in terms of the defeat of the Commission, General Court, so very long judgment, fine. But then if you look at it from the perspective of state aid law, it's a judgment that relies on the other two big fiscal aid cases decided by the Grand Chambers. One is the Financial Goodwill 2021, which is an extremely conservative case, is a sort of the last chapter of a long saga on tax and a sort of a tax relief that Spain granted to those companies which were investing outside Spain. And the court found that that was actually a selective measure, sending, you know, all new tax lawyers in a sort of a panic because the court expressed itself in very broad terms. Any kind of derogation is a selective measure. And the sort of the last Financial Goodwill judgment 2021 is instead, in my view, a very clear attempt of the court to go back to a sort of much more procedural selectivity, a much more narrow view. And that's one of the judgment that is actually copy and paste in the Fiat judgment. The other judgment that the court relies very heavily in the Fiat judgment is the Poland and Hungary judgment. Again, another Grand Chamber decision on the turnover taxes in those two countries, where, and we'll discuss it later, which is, again, with all due respect, an extremely generous judgment in terms of member states' competence. So Fiat, yes, it has to be related to Commission decision and the General Court judgment, but also sends a signal, in my view, where, you know, of the new attitude of the Court of Justice towards fiscal aid, which in my view is really very, very different from what the approach that the court took a few years ago. And it's much more pro-member states, if I may.
Indeed, Andrea, I think that that's what I see as well. I think there's a real coming back to first principles here, and just to build a little bit on what Ruth offered us a moment ago around what is the appropriate reference system here. And I think that that's really the nub of what we're looking at. And what you see here is this clear shift away from the Commission's primary position, which is this very expansive member states corporate tax code as a whole concept, where what it's looking to do is to say what you're testing this against is this concept of taxing or profit earned by every resident, disregarding this group concept. But then this, of course, raises this issue of effective comparability in terms of preventing competitive distortions. And so what we've seen is this coming back to this first principles here and saying, well, hang on, what is the right reference system? And the right reference system is what the Grand Chamber is saying. You know, here we have the domestic transfer pricing legislation in the state. There's a state sovereignty question here. The member state is sovereign. And when you're looking at that, then you're going to have to apply that as your reference. And so we've got TP, domestic TP legislation in Luxembourg, administrative guidance, and of course, rulings and practices, and it narrows it down. However, just to answer something that Paul raised earlier, I think there's this also really interesting dynamic here, because the Grand Chamber doesn't then deal with this issue of whether Luxembourg applied their domestic rules correctly. And that's a really interesting question about whether that's about the way the matter came forward. I mean, just from other people's views here, in fact, the way the matter progressed forward, that was not an open argument at this point for there to be any position for the Grand Chamber to respond to that because of the way the case was presented by the Commission on the way through. So I'll leave that for someone else to consider.
I wonder if, to answer that, the CJEU would say, yes, indeed, the Commission had effectively shot itself in the foot in the sense that even when assessing whether Luxembourg had given a ruling that was in compliance with Luxembourg's own law and relevant guidance, the Commission still introduced a external arm's length principle for purposes of checking whether that was the case. And so in that sense, they went wrong, even in relation to the question which we might back in 2015 have thought was the question that they wanted to ask, namely whether there was here a form of sweetheart deal for a particular multinational.
Yes, I mean, perhaps I could just say this, that this is an appeal. This is an appeal to the General Court. And so the Court of Justice is confined by what is on appeal. And what is on appeal is the judgment of the General Court. And this is a very important point to bear in mind. One is not appealing the decision of the Commission to the European Court. What one is appealing is the decision of the General Court. They're two different things. And many, I was amazed at how often people would simply fail to draft a proper appeal because they'd appeal against the Commission decision, which is inadmissible. What you've got to appeal against is the judgment of the General Court. And what you have to show the court is that there's an error of law in the judgment of the General Court. We're not interested in what the Commission said. Although what is interesting, perhaps we'll come back to this, is that when the court hears an appeal, the first question is the appeal well-founded? That's to say, is there an error of law in the judgment of the General Court? The next question which arises, which is often the more difficult question, is what should the court do next? And there are two options. One is to remit the case to the General Court to effectively then decide the case applying the law correctly. And the other is effectively to take the case up themselves and to decide it themselves. Obviously, in one sense, the latter is much better because it then effectively means you don't have to have more litigation. And that is the course that the court took in this case. And there is a question that I'm just going to throw open, the question I'm not going to answer it, is whether in fact, in that part of the case, and this really goes back a bit to what Sarah and Paul were saying, whether the court was, if you like, right or fair enough to the Commission in saying, well, there's no point in this going back to the General Court because effectively the Commission got it all wrong. Now, does this prompt any question or observation from anybody else in the room? Yes. Perhaps you could just say who you are and because we're being recorded. Yeah.
My name is Ann Mumford, and I teach here at King's, and I want to thank all of you for your incredibly fascinating presentations, because I feel as if I've just completely changed my understanding of the Fiat case, thanks to all of your insight. I came into the room thinking that, oh, this is perhaps an end to the era that we've heard discussed over the past couple of years, that state aid tools are being used to attack tax problems, and that this is controversial, and that what are really tax harmonization issues are being treated as if they're competition law issues. But when I listened to Steve's really interesting information on the background, it started to feel a little bit like a state aid issue to me again. But then I heard the really interesting discussion of, well, we need to figure out the reference point, right? What tools are we working with? And I thought, oh, maybe actually I was right when I came into the room. This is about the decision to treat tax problems as if they are state aid problems. And I wondered if I might share my confusion with the panel and see what you think. Is this about deciding which camp problems like these fall into? Are they tax harmonization problems, or are they state aid problems? And we need to define the fields. Thank you.
Like to Andrea.
I'll go first. Again, I think that the Fiat judgment is quite strong. I mean, it's quite tough on the General Court, because the two error of law that the CJU actually said, look, you got it wrong. Yes, you got it wrong on interpretation of Article 107, paragraph 1, but quite astonishingly, they simply say you also, you General Court, violated two other provisions of the treaty, 114, paragraph 2, which simply say you cannot harmonize taxation, and 115 that requires a unanimity. And that's a big statement. So in other words, that, you know, if I can simplify, General Court, it sort of, went beyond the competence, by endorsing the Commission decision, they actually violated the sort of two of the slightly more precise articles on competence of the Union. You cannot do it. Also, and again, that's really going to be, in my view, is one of the most important paragraphs of the judgment, because at the very end, the court says, look, I know that there is a problem about harmful tax competition in Europe. I know that's a problem. And I'm not saying that the Commission should not have any power to investigate fiscal aid. Fine. But then they come up with this test, which is paragraph 100 and, wait a second.
It's like 119, maybe?
Wait a second. 122.
122.
122. And they simply say, you can investigate. However, in order to investigate, you need to show that there's been a manifest sort of discrimination in favor of certain companies. You have really, it's a very high standard. The court speaks of manifestly inconsistent with the objective of non-discriminatory taxation. You have to, and again, it seems to me that the standard to prove that there will be a sort of unlawful fiscal aid is so high that there's a little bit less room for maneuvering for the Commission. So in other words, yes, we want to acknowledge that harmful taxation is bad for the internal market. And in theory, if I may, I'm getting excited here, if I may, state aid is also about, because, again, the judgment is very traditional in the sense of state aid is only limited to one country. But, the Commission duty, every time they need to analyze a certain measure, they need also to check whether there's any impact on free movement. And the courts here acknowledge that, but at the same time, they put such a high standard to show that there will be a sort of unlawful aid that I wonder what's left, because manifestly, I don't know, I think it's going to be a very high standard for the future. So if I may, it's more on, which could be good. I'm not saying that it's bad or good.
Yeah, I would just say I think it's the strongest affirmation I've ever seen in a court of justice judgment of the importance of tax sovereignty. I don't think I've ever seen words as crystal clear as what the court of justice gave us. And I also think that there are parts of judgment which are kind of unfair on the commission. And I know Andrea is going to be touching on this in a second, but you know, the commission did try and say that it was using member states' tax law to determine whether they've been an advantage which have been granted, but that was flippantly rejected by the court. And also looking at Vodafone and Hungary, I think that the judge, I think the court justice also was kind of unfair to the commission and the argument the commission was running there. So I mean, this is segueing off Fiat, but the commission's argument was kind of recharacterized by the court as saying progressive taxes per se are something which is problematic from a state aid perspective, which would be stupid. And I don't think the commission was trying to say that, but that was the argument that was, you know, recharacterized by the court. And obviously, if that's the argument, then that can't be right. Same thing here. I think that part of the commission's argument was kind of recharacterized. When I say it's unfair on the commission said a lot of things in its decision in the first place, and the general court said a lot of things. So it's not unsurprising that, you know, their argument did get recharacterized in that kind of way. And I know Ruth probably has something to say on the legitimate role of the state aid rules today going forward. What can the state aid rules do with respect to harmful tax competition? They can't use state aid to rewrite the international tax rules, but there is some kind of legitimate place, which is what the Court of Justice tells us in paragraph 122.
Ruth,
Did you want me to speak to that, Steve? So, you know, just on this question from Anne about, you know, is this a competition issue or a harmonization issue? I think it is a competition issue. I think, of course, rulings can be used as a vector to deliver state aid, and that is a problem. That's a problem that the commission is specifically empowered to deal with in the treaty. The problem is that the way the commission went about trying to deal with this competition problem is by applying a harmonized rule. They wanted to apply the same rule in all the cases to all the states, regardless of their domestic law. And that's where they went wrong. And I think the reason why they wanted to do this, and this, you know, this is editorializing, okay, but the reason they wanted to do this, the commission really had its heart set on winning Apple. And it couldn't use Apple's own reference base against it and win that case. And so it invented this other rules, the EU state aid standard, that it could use in Apple. And because it wanted to use it in Apple, it used it in all the other lower value cases. And so it really committed it, put all its chips in the pot on this, you know, EU state aid standard. It gambled and lost. I think it could have won some of these other cases if it had taken a more traditional approach, which said, hey, you know, or as Paul was saying, like, look, it looks like the administration, and I know Steve has written about this as well, the tax administration hasn't really followed its own practice here. As a more traditional, you know, a smaller bore intervention in this area, I think would have been more successful in these cases.
I might also say that whilst perhaps this will mean that the particular avenue for tax harmonization, if that was what you're going to call it, and doesn't seem too unfair to me, that the commission was pursuing here has been closed down. That's not to say that there won't still be cases where, taking a step back, what is going on is that the commission is seeking to use the state aid rules in order to counter what it perceives as inappropriate corporate tax policies by member states. And I say that because one of the forthcoming appeals before the CJEU is the appeal of the UK and various UK taxpayers in the against the commission's decision, or sorry, appealing against the general court's decision to deny our applications to annul the commission's decision in relation to the UK's CFC rules. And in that context, it is, to my mind at least, pretty clear that what's going on is that the commission is seeking to use the state aid rules as a tool in order to prevent the UK from having a particular form of CFC regime, which the commission doesn't like, but in circumstances where, frankly, it's pretty hard to see how it is state aid.
Yes, well, I'd like to make two observations on this very interesting debate which has been launched by your observation. First of all, I think you have to bear in mind that we're dealing with taxation, and the Court of Justice, possibly much more than the General Court, is very sensitive to the fact that direct taxation, we're concerned with here, is within the competence of the member state. Now, coming to Steve's point about, and indeed Andrea's point about Commission and Hungary, Commission and Poland, the tone of the taxes, there are interesting cases, because if you look at, and indeed the Commission demonstrated this before the court, that if you take, when this was the advertising levy, that in fact it only caught large foreign companies. It didn't catch Hungarian companies the way that the tranches were fixed. Now, just imagine if we switched that case from taxation to nationality, case on nationality. Plainly, the court would have said that is discriminatory, it's got to go, because the fact is that it's only unfortunately Italians who've got a villa in Capri who are caught by this, is plainly discriminatory, I exaggerate slightly. But we're dealing with taxation, and so that a case on discrimination, which, if you like, could be made out on the fact that the only people who were clobbered were foreigners, the court effectively said, well, actually, there's been no harmonization of this taxes, and tax is something which is require unanimity to do, and therefore we're going to allow Poland, we're not going to say what Poland and Hungary did is in breach of the treaty. So that shows that on something like discrimination, it's applied in a different context in relation to tax, non-tax. And of course, this all goes back to the Schumacher case, which is probably the most important tax case decided in 1993, where we all know, again, that discrimination on grounds of residence is disguised discrimination, which is prohibited unless objectively justified. In that court case, the court recognized that the distinction of residence is a fundamental principle in tax law, and therefore that a non-resident and a resident are not in a comparable position as a general rule, although there can be exceptions, and therefore the distinct difference of treatment between residents and non-residents was not discriminatory.
Could I add something here? Again, an outsider's perspective. So, on these Vodafone, so, I asked around, what's going to happen with these state aid cases? Is Ireland really going to collect this $14 billion in recovery from Apple? And the answer I got back from academic colleagues in Europe was, there's no way that the Court of Justice will overturn this decision. It's too big, it's too political, they won't undo it, okay? Then you have this ruling in Fiat, which seems like points very clearly to actually overturning the commission decision and, the general court decision. But by the same token, that Vodafone decision is the opposite. So the Vodafone decision seems to me as an outsider exactly as political as the Fiat decision is apolitical. To me, the Vodafone decision is all about digital taxes. And the holding in that case is totally useless in the sense that if the question is the one that Steve described, right, are progressive taxes illegal subsidies? Of course the answer is no, but that's not the question, right? The question is it discriminatory if you adjust your tax such that everyone who pays at the highest rate is foreign and everyone who pays at the lowest rate is domestic? And that's not a question that the court reached. But at the same time, and this isn't obiter dictum, right? But it does send a signal to litigants who might come before the court to challenge digital taxes, which is to say, we are going to bend over backwards and violate our own precedent in order to avoid answering this question on discrimination.
Good. Well, now I'm conscious of the time because it's now 7:25, and we've got Steve has put forward these almost a sort of exam question. But we're going to go. Bit like any question, questions. And the next question is in fact for Andrea, and I'm going to depart from my brief, but we're going to give the floor to Andrea, and the others, if they wish to, can comment briefly because we've still got some questions to go. Now, the question for Andrea is this. The decision of the European Court reaffirmed the importance of domestic law when determining the reference framework. Although the Commission argued in its subsidiary argument the treatment of Fiat by the Luxembourg tax authority also diverged from Luxembourg tax law, as well as the OECD arm's length principle. The European Court appeared to dismiss this subsidiary argument out of hand. Was this a direct message to the Commission, Andrea?
Well, I think that we can deal with it pretty quickly, because again, the court expressed its displeasure in sort of slightly quite openly, because I think that's this is just a superficial argument. So clearly, I mean, again, this is also related to the dynamics of state aid cases, because sometimes you have the court says, okay, you got it wrong, so by implication, maybe annulling a general court decision, and at the same time, sort of addressing some of the issues in the Commission decision. So therefore, in theory, the Commission obligation would be to comply with the judgment, perhaps with a new decision. By dismissing any kind of argument, sort of supplementary arguments, I think that again, it seems very unlikely that the Commission can start a new decision exactly, because, you know, they should what kind of new decision they can come up with. So I think that that's probably a clear message that, I mean, everything is possible. In theory, the Commission has the power to start a new investigation, to reopen the decision and to come up with a new decision. But by dismissing so radically the sort of alternative argument, I think that's probably the end of the road. That's
Anything?
No, that's it. I'm happy to move on. Sure.
Well, no. What about in the last people that we want to shut up in the way of the audience? Is there anybody there who would like? Yes. Yeah. Sorry, just one moment. I think we may need the microphone because this is being recorded. Sorry, just tell us who you are.
Yeah, Liz Keeling from McFarlane's, tax lawyer, and very late to state aid also while we were outing ourselves. The thing that did strike me about the judgment was the endorsement of the Gibraltar case, which I thought was quite interesting. It felt a bit like it was just segued into the judgment, almost as though the court wanted to say that it endorsed the Gibraltar case, which was all to do with the effect of the state aid, or the effect of the aid, rather than if it was actually written in the legislation. I wondered if you had any comments about that, or if anyone in the panel thought that was significant or not.
Yeah, I think by bringing up Gibraltar, you're also trying to send a message to member states: don't take the mick with your tax code, which is what was the case with Gibraltar. So I think that's the direct message. Don't try and formulate your rules in a way in which they're facially neutral, but the effect of them is going to be to just advantage certain companies, multinationals essentially. And Ruth Mason has written fantastic stuff on the Gibraltar case also.
Yes, I think the other thing that the court was doing is it's looking also to the question of legal certainty. And I think what they wanted to do, and this is again a technique that the court uses, it wants to send a signal to the outside world that you shouldn't imagine that this case in any way chips away at what Gibraltar says. And this is, so the message is that there's no inconsistency, or you can't use this case seek to re-argue Gibraltar. And so this is very important for those of us who study European law and have practiced in it, is what I call the continuity of the system. And as you know, it's very rare that the court will overrule a previous judgment. And there are cases where the common law technique of distinguishing judgments happens. And also, if you like, distinguish them possibly almost out of existence. And I think what the court was anxious to show here is that there is a continuity in their state aid judgments, and you shouldn't take it that sub silentio somehow this judgment has undermined what was said in Gibraltar. And that's the message which is obviously important for your clients as well, or for you to pass on to your clients. Yes.
Just talking about messages that are important here. And like, I think this is really important to just say that, you know, this judgment does not stand for the fact that state aid in tax has gone, because it has not. And, you know, we have to really just hark back to really thinking about how state aid arises, whether it's within the context of a regime, or whether it's in the context of the administration of the tax law of a particular state. And it's really important to be able to think about those two contexts in which this will arise in the future. And so I think for taxpayers and for fiscal authorities, and also for governments, for member states governments, to think about if you think that it's really important from your perspective in terms of tax sovereignty, that you have a solid national law, and you want to have a think about how that sits within the context of your EU framework and what you have agreed at that EU level. I think there's a real interesting question there about how does that play through in terms of EU law in the adoption of unified taxation. And we can just think about this a little bit politically for the minute. Of course, we're talking about the introduction of Pillar 2, and there is a real interest here around about whether Pillar 2 is something that should be introduced at that EU level. And I think that this judgment may be something interesting for member states to be thinking about in that context. So I might just leave that one settled there for a minute. And I've got some other things to say, but I'll come back to them later.
Good. Well, I think it's now time to move from the present to the future. And I'm going to ask the panel some questions about the future. And the first question is this: has Fiat and the other state aid cases changed for the better the tax ruling practice of the authorities, tax authorities, or is it likely to do so? And perhaps Steve, you'd like to go first on that.
Oh, yeah, sure. Yeah. So with this question, we want to bring up the fact that the world has changed so much since these cases were taken. So 8 years ago, when this all began, BEPS was in its infancy. We didn't have a multilateral instrument. We didn't have exchange of information like we have today. So the world has changed considerably. We also now have anti-hybrid rules that prevent lots of the tax structures that were at issue. And critically then, within tax authorities themselves, processes have changed. So 2014, you could just go to one person in the Luxembourg Tax Authority. That's no longer the case. There is a body with 6 people that has been established. Rulings take about 6 months rather than taking a couple of days. The Netherlands publishes summaries of tax rulings, and Ireland also now has a program for bilateral advanced pricing arrangements. So the practices within tax authorities have considerably changed. So in a sense, the Commission has won if the battle was just in respect of dodgy tax practices.
Paul, perhaps you'd like to give your impressions.
Well, I would agree that practices have changed considerably, and also that client perceptions on this have changed. And so as far as tax ruling practices are concerned, I think perhaps the main change there has actually come about through the requirements under the Directive on Administrative Cooperation for cross-border tax rulings to be exchanged between tax authorities. And what that seems to have led to amongst multinationals is a reluctance to ask for a tax ruling that might, if it's given, then need to be exchanged. There's just a sense that you don't want to be the subject of a tax ruling that is exchanged between tax authorities, however benign or appropriate it might be to have sought the tax ruling in the first place. So I would certainly say that the environment for that sort of thing has changed dramatically. And whether that's a result of, I'm not sure that's a result of the Fiat litigation, but it's probably a result in part of the prominence which the Commission has given to it through the efforts it's made in this particular state aid context.
Yeah, just following on from what Paul has just said, I think that's really correct. And we've got this sort of situation now where I wonder whether what we'll see is that maybe a slight balancing back of that. I think if you weren't going to achieve tax certainty because there was uncertainty about the application of state aid, which I think has been going on for such a period of time now, that now there's an opportunity to think about in the current context whether the advanced ruling systems in any one of the member states and also rest of world where they do apply APAs, for example, is that a system that's fit for purpose, and are people achieving tax certainty? And that's not just for taxpayers, but it's also for fiscal authorities to get a better understanding of whether they can maintain an arrangement of tax certainty. But of course, you've got to see that in another context as well, because if you enter into a ruling and you, as a taxpayer, don't implement or comply with that ruling, then there really is the importance for the member state to be able to seek to ensure that it's been complied with. And there's a question about whether non-compliance and non-enforcement of non-compliance is in and of itself a state aid. And so that really comes down to a question for both fiscal authorities and for taxpayers in this circumstance, where when you go to negotiate a ruling, to be really clear about what you're putting on the table and what is the evidence and documentation that you're putting forward in order to establish the circumstances upon which the fiscal authorities rely in terms of granting that. But it's also for the fiscal authority to consider, well, what do I need to have in place in terms of the governance arrangements around ensuring that I have applied my national law in accordance with what my tax code has to say and what my administrative guidance has to say about that. And how do I actually document that? Because if I'm called upon to give proof, what is the proof that I'm going to need? And that's, again, the same circumstances for a taxpayer. So it's about contemporaneous documentation here.
That's an interesting glimpse not only into the future, but also in the sense of what Steve and Paul have said, how in one sense the Commission has had the success in improving scrutiny and transparency. Now, we are now going to gaze into a crystal ball, because the next question is there a future for fiscal state aid litigation after this judgment? Probably everybody in the room says, well, we hope so, but we'll see. And what does it look like? Maybe even what should it look like? And so I'm going to hand over to Ruth to tell us what she's seen by gazing into her crystal ball.
Great. So, I mean, I definitely am in the I hope so camp. I think, one of the things that's so unfortunate about the litigation strategy that the Commission undertook in these cases is that it ends up raising the question of whether the Commission should even try to do anything in these cases. I think that's a pity, because, as I said, I think tax is a major vector of state aid, including the provision of rulings. And if the Commission doesn't police it, then you're going to get major distortions. And, one only has to look at what goes on in my country to see just how big those distortions can get. So I don't know if people abroad are aware of this, but a few years back, Amazon ran a contest for all the localities in America where it said, where should we locate our second headquarters? Amazon. HQ2, and the localities submitted proposals to Amazon describing to them all the goodies that they would give them if they located in this particular place. Of course, many of which, or it took the form of taxation. One town promised to name its name the town after Amazon, right? And Amazon did this completely publicly, brazenly, audaciously, playing the localities off of each other. And I think you wouldn't get to that point in Europe, but you can have something on a smaller scale that's also damaging. So my view is the commission needs to regroup and recommit itself to state aid enforcement, but it has to do so in a more predictable and rule-based fashion, ideally one with more input from tax experts. I think the international tax system has kind of a house of cards quality to it, and non-tax experts probably aren't the best ones to pluck cards out of this system, which is, you wouldn't attack the arm's length standard if you knew a little bit about tax. I think, if there had been more tax advisors in the commission at that time, someone, the commission could have been led away from this particular litigation strategy. The original approach to identifying tax state aid is a tax expenditure approach. As I understand it, this approach was introduced to the commission by tax experts and specifically by students of Stanley Surrey from Harvard. Stanley Surrey was a big proponent of this concept of a tax expenditure. The concept is you look at the general tax law, and then you look for deviations, and those deviations constitute tax expenditures. And I think the commission should welcome or at least consider approaches like that are more tried and true, that tax experts have been working with for a while. So in my academic work, I've argued that this tax expenditure approach works well most of the time, but it doesn't work where the feature that's being considered as potential state aid is a structural rule, like an allocation rule, or like the Gibraltar situation where it's the whole corporate tax regime. Structural rules are by custom incorporated into the reference base and tax expenditure analysis, so there's no deviation. And so you never register any kind of tax expenditure, so you never register a subsidy. So what I've suggested for tackling allocation rules, for tackling structural rules, is something that the US Supreme Court uses when it analyzes allocation rules and whether they're discriminatory within the meaning of the US Constitution. So the court just has a rule of thumb. It says, suppose all states applied the challenge states rule. Would interstate commerce bear more tax than purely domestic commerce? So conditions of hypothetical harmonization. If the answer is yes, the Supreme Court says, well, there's discrimination there and it's unconstitutional. But this test could easily be adapted to identify selective subsidies. You just universalize the rule and ask, does cross-border commerce pay less tax than purely in-state commerce? And then you would say, so for example, if the state's income allocation rules don't allocate 100% of the income, so the domestic companies pay tax on 100% of their income and multinational companies pay tax on less than 100% of their income, then you would say, well, there's a putative state aid there and the state would have to justify it. It's a pretty good first pass at how this works. And we have experience with it in the United States. So, the tires have been kicked on this method already. So that would be my suggestion.
Good. Well, Steve, perhaps you can look more at this side of the Atlantic and within the EU.
Yeah, well, I hope this is the end of it, because state aid cases have given me my biggest articles and my biggest journals. So they've been profitable for me, not in an economic sense, but certainly at work. And I've always thought that there was a legitimate role for the state aid rules here in dealing with the administrative improprieties on the part of member states. But my argument in an article in the Law Quarterly Review in 2021 was that you need to readapt the way in which you look at the state aid rules. So you say, what's the reference framework? Has there been a deviation from that's been selected? So you say the reference framework is administrative law, and then you say there's been a deviation where the tax authority has acted unlawfully. And that goes right to the heart of the issues that I saw in those initial opening decisions. So was Ireland motivated by a desire to increase foreign direct investment in the country, and was it concerned about increasing employment? Was that the reason that the ruling was granted? And something like Luxembourg, was the idea that these were sweetheart deals? If so, they're contrary to Luxembourg administrative law. You could say that they're state aid. It tackles the root of the problem. And to me, that seems like the way in which the state aid rules should have been used, but they can't be used to rewrite the international tax rules. The state aid rules have I think, a narrow role in dealing with issues of harmful tax competition. There's also there is a kind of broader and more fundamental problem with using state aid rules generally in this tax context. Because if the suspicion is that member states were being overly friendly with large multinationals in order to encourage them to invest, then through giving the sweetheart deals, they've gotten the companies to invest. And now if that is in fact unlawful state aid, they have to recover that money. But that means that Luxembourg, Ireland, the Netherlands, they are the ones that would get the cash. So they've given this kind of incentive in the first place. And if it is actually state aid, they get it back. So it's a double win for them. And that's a more conceptual issue, I think, with the state aid rules. And critically, with the case with Fiat, a costs order was awarded against the Commission. The cost must be astronomical. And the money was never going to go back to the EU budget in the first place. It wasn't going to go back to fix the internal market in the EU. It was going to go back to the member states who apparently had erred in the first place.
Well, to reassure those of you in the room who still are EU taxpayers, I can tell you that all the cost the Commission will pay will be a fraction of the Fiat's cost, because that's the way the court taxes cost. But that's another issue. Now, I'm conscious of time. Also conscious of the fact that drinks have been nicely set out at the back. So what I'm going to do is move on to the last question, and then I'm going to bring in all members of the panel, and then also the audience, and then we will break for drinks, and the discussion can continue there. So the last question, and in a sense, Steve has just touched on this, and he's made a very, very good point. In fact, it was a point that was made by Sir Jeremy Lever about 20 years ago in an article. I don't know if it was in the LQR, but I mean, absolutely, that it's a win-win situation for the state. So the question is this: recovery is very complex in the case of tax. What are the most significant issues, and do these suggest that state aid is not a good tool for regulating benefits that may be provided by the tax code? And perhaps we'll start with Paul on this first.
Well, my perspective on recovery is somewhat skewed by the experience in the CFC state aid case, where we've ended up litigating over such a bizarre formulation of supposed state aid that the question of recovery has become really quite arbitrary in terms of the taxpayers who ultimately are found to have received state aid in that case, based on the way in which the Commission reached its final decision. So the opening decision in that case was rather broader in scope and would have seen the UK be required to recover state aid in the form of taxes not levied across a broader swathe of multinational activity. But the final decision ended up being formulated in such a way that the taxpayers who are said to have received state aid can't, on any sensible, rational policy basis, be distinguished from those who have done much the same thing, but seemingly not received state aid. And so I think what I'd observe is that, separate from Stephen's point about whether it's really giving the right sort of incentives in terms of member states' conduct to say that if they err, they must take back the money they've handed out. What I'd observe is that when you try to apply, or when you find yourself applying state aid outside of sort of individual taxpayer cases, the question of recovery can become extremely fraught.
Right, Andrea.
We want to finish with recovery. Again, very complex, clearly, in particular in tax cases, because Commission does not usually identify the beneficiaries and does not even quantify how much. So obviously, the whole burden goes back on the member states with all the problems. And in particular on taxation, because in theory, recovery is supposed to be about restoring the status quo. But obviously in taxes, what kind of benefits, what kind of deductions would have been actually put there. So it is particularly complex. And again, the Commission attitude is very rigid, because if I recall correctly, they seem to say only those deductions which are automatically granted under national law, international law, can actually be taken into account. At the same time, well, maybe you should take into account a little bit of a wider options. There might be some more favorable treatment that you can actually, the taxpayer can enjoy. The Court of Justice in a recent judgment, the Fossil judgment in concerning double taxation in Gibraltar, again, simply say, yes, maybe we should try to take into account that it was possible for Fossil to have relied on a double taxation case. So it seems to me that, again, there might be some kind of leeway to discuss this point. But again, it's hard to reconstruct the status quo in a tax case. And that's exactly the problem you have when you actually get into the recovery international law. But it's going to stay, because recovery is obviously provided under the Subsidy Control Act. So we're not going to get rid of recovery. It's not just a law problem. It's going to be a...
Yeah, Ruth, do you want to talk about recovery?
Yeah, so I teach an international tax policy class here in Virginia, and in the past couple of years, I've done one of the sessions on state aid, and I have to say, the recovery is the thing that my students have the hardest time with. They think it's completely bonkers that the state, the very state that was supposedly the bad actor that violated EU law, then gets a reward for having done so. It's really hard to understand. And I don't think it's just because we're American. The problem in these cases with the state aid recovery mechanisms, the commission only has one state before it, but really lots of states were involved in, like, let's say the Apple tax plan. Lots of states lost tax. It wasn't just Ireland, and arguably it was the least Ireland, right? Like that was U.S. tax, that wasn't Irish tax. But you only have the case against one particular state. The other problem is, in the reference-based cases, not every case is a reference-based case, but you still have to figure out what the recovery is. So, like, imagine that Gibraltar had not notified. It just implemented its system, and then the commission said it was state aid. What would be the measure of the recovery? And I think there's more than one case like that. Any kind of rate case where there's two different rates, like even in the turnover tax cases, is the lower rate the right rate? What if there's three rates? And I just think the measure of the recovery is something that's really difficult, even if the goal is to try to put the parties into the same position they would have been ex ante, which, for the reasons Andrea just said, is totally impossible because their other behaviors would have changed.
Yeah, I'll just say one more thing, because there's a bit of robbing Peter to pay Paul about it. So in the Apple decision, it was mentioned that if other member states were to try and get whatever tax they were due, then Ireland was entitled to less. And that's the way that transfer pricing is going to work generally. So, if there was a negative decision against Fiat here, and Fiat has to pay more tax in Luxembourg, maybe then it gets a transfer pricing adjustment that means it pays less tax in other member states. So there is a need to look at it holistically. And I think that demonstrates just how ill-placed the state aid rules are to deal with complex issues of international tax.
Yes. Now, I want to give the audience a chance of commenting. Should anybody who
And if anybody online has any questions, you can add them in the chat. Apparently there are none online.
They can't even have a drink.
Well, I think probably everybody is now.
I think there's one question from
Oh.
a fellow lecturer at King's.
Yeah.
I don't understand the
We'll have a good European compromise. We'll have a question.
Okay, thank you. I'm Darren Harvey. I'm a lecturer here at King's. I'm a colleague of Andrea and Stephen. I'm not a state aid lawyer. I'm not a tax lawyer. I'm just a European Union lawyer with enthusiasm for these kind of things. I should probably get a life. If I were to focus on the question of competence, because Steve mentioned earlier on in the discussion that if you would permit a competence question, a general competence question, as opposed to specifically on the last question you'd asked, you said you hadn't really seen such robust language before on defense of the member state competence in direct taxation. And I wonder, is that itself a more significant general marker being laid down by the court? I mean, in a narrow sense, you can read this judgment as a series of administrative errors, if you like, by the commission and an error of law by the general court, which results in an infringement of the principle of conferral. In another sense, you can say it's actually a more robust principled articulation and defense of a general Article 5 principle of conferral type point. And from that perspective, looking to the future, how much of a marker is laid down by this case, and how likely is it to be a landmark case moving to the future? Because I always think, from my background, of cases like tobacco advertising 1, where everybody got tremendously excited about the Court of Justice finally playing its role in policing competence properly, and depending on who you talk to, that hasn't actually really happened much since. So I wonder to what extent one might view this case as a technical issue which touched on the matter of competence, or, if you have to make this distinction, perhaps something more profound about the nature of the division of competences and a line beyond which the Court of Justice is not willing to go. In this instance, in areas of tax, could well be a discussion for drinks, but I felt I would raise it now.
Oh God, that's a massive question at the end. First of all, it's a different language, that's for sure, because all these judgments, they always start with although fiscal policy is a matter for member states, you have to exercise it in a manner compatible with your law. Full stop. That's the classic statement. In Fiat, you have 3 extra points. A, when the Commission looks at selectivity, which again is the application of Article 107.1, if it's a fiscal case, they need to pay respect to the fiscal autonomy. So once again here, of the member state. So what the court is saying, that in applying the treaty, you have to make a distinction when you look at selectivity for fiscal aid only. And in theory, state aid control does not depending on the regulatory competence of the member state. Should be always the same, whether it's actually energy, car, or taxation. What we got now, clearly fiscal aid is per se. Then the court comes up with this idea of the tax autonomy, plus even that the tax legality is, you can't take into account any external sources because otherwise you breach the principle of tax legality, which is a fundamental principle, blah, blah, blah. And the court actually cites a case on VAT, which is, they say, is exactly the opposite. So I thought it was quite funny because VAT is the only EU tax. So I think the message is pretty straightforward that we are going through a moment of a sort of slight repatriation of certain kind of powers in conformity with the Poland and Hungary case and both of them. Sorry, that was short.
As a tax lawyer, my perspective on this is that the Commission here was seriously overstepping the mark in terms of what it was seeking to assert as essentially an EU level principle. So the application of an arm's length principle in particular circumstances to particular transactions as between particular parties is something which generally produces swathes of law within each jurisdiction. So within the UK, we have different rules on what is market value for different forms, different assets. We have different codes dealing with capital gains, with intangible fixed assets, with loan relationships in the corporate sphere. And within all of those, you have different provisions that might substitute an arm's length or a market price for particular transactions where they're undertaken between related parties. Relatedness might be defined in different ways. Grouping might be defined in different ways. And this is just within the UK. And before you start thinking about the application of OECD principles in a treaty, there's a huge swathe of law there. And the Commission comes on and says, no, we know better. No matter what your domestic law says, there is an arm's length principle at play here, and we find it because we say that it is a purpose of your code to tax standalone and integrated companies in the same way. And as to what the content is of that arm's length principle, well, we decide that. And to, as I say, to a tax lawyer who's used to having to find the very particular question that's in play and to determine whether the relevant nexus is met between the parties, and then to figure out what exactly the rule is that you might need to apply to substitute a different price to the one that's actually been selected, and whether that's domestic or treaty-based, OECD-based. To have the Commission come in and say that just seemed extraordinary. So my perspective is that they deserved a significant slap on the wrist in the form of that bit in the judgment. But equally, I'd say, that doesn't then mean that they won't continue to pursue fiscal state aid cases in other contexts.
Yeah, and so I agree with what both Paul and Andrea just said there. And I just say, from the perspective of the UK, although outside the European Union now, this would have been the thing that the Treasury was arguing in the 90s in cases like Cadbury Schweppes, Think Cap litigation, and in all those other ones. And we had restitution cases until last year dealing with what to do with advanced corporation tax that was contrary to the fundamental freedom. So I think that this is also a direct message to the Commission. Stop taking these cases about specific provisions in member state tax codes on the basis of general provisions of the EU treaties.
Yeah.
Yes, so I'm in agreement with everyone, but I think, it's definitely that clear shot across the bow here. And it's going to be really interesting, I think, to see what the Commission does in terms of its approach to investigating state aid and what we're going to start to see after this. So we're not going to see it instantly, but let's see what the next couple of years brings and what the tone is that changes and shifts, and whether there's a slightly different tone and change within the EU as well.
Good. Well, I think I give the last word across the Atlantic to Ruth. You want to add anything to what the four panelists have said?
So I'm not prepared to say yet. I think it's too soon to say that there's a general increase in deference to member state fiscal autonomy. I think that the Commission really overstepped in this case and sort of had, as Paul said, had to be, this is the answer that had to be given. And I don't think we necessarily have to draw implications for other cases. I think Vodafone and Tesco Global really are about protecting the idea of digital tax, and they might not be about anything else. And so if those things are true, then you could still have the Court of Justice pursuing sort of, enforcing the fundamental freedoms in a rigorous way, and likewise the prohibition on state aid in the tax area in other cases. So for me, it's too soon to tell.
Good. Well, now remains for me, you only have me between you and drinks, to thank the panelists. I think some of you might, for goodness, want to go to a seminar on tax at 6:30 on a Thursday evening in December, when there are many better things, or superficially better things to do. But I think this has been an absolutely fantastic evening. We've really had a huge amount of brainstorming. And I'd like to thank two people in particular. First of all, Steve, for having organized this, which required quite a lot of work, if I can put it like this, behind the scenes. And of course, the fellow panelists, but also you, the audience, for having played your part in making a really stimulating evening, which will now finish off in the normal way. And I would ask you in the normal way to thank our panelists.